Good morning. This is Sinta Ebersohn from Fair Divorce, and I'm going to interview Errol Goetsch from the Justice and Reconciliation Center about divorce, what makes a divorce fair, and how are we entitled, if we are entitled to a fair divorce and an agreement. Welcome, Errol, and thank you for joining me again.
Welcome. Nice to see you again, Sinta, and the audience.
Okay. We spoke about unfair divorces and a lot around divorce in our previous interview, but this time around, I want to ask the question, what is a fair divorce? What does the law say? How are we protected to ensure that we are all entitled to a fair divorce?
There's no straightforward definition of a fair divorce in the Divorce Act or the Children's Act. So we have to glean the meaning from what we see. So in my opinion, taken from the Children's Act, a fair divorce is 50-50 and it's produced by a particular process. It's produced by a mediation process in which the voices of both parents and the child and the family are heard.
Yeah, I think fair is also a matter of perspective. So what might be fair to me might not be fair to the next person. So it's
50-50 is that objective standard. Now, 50-50 doesn't always mean 1 week on, 1 week off. It can mean month on, month off. But it really means that in the negotiations, the parents have traded off equally and happily whatever advantages they've got to arrive at a custodial or patrimonial arrangement that is in the child's best interests.
Yes, I agree. And as long as 50-50 is the starting point, and then we work out what is practically sustainable by the parties involved.
50-50 is the starting point, and it's produced by a fair process. So mediation is key. The Children's Act is absolutely clear. The confrontational process, so read that as litigation, must be, it's compulsory, must be avoided. And it's absolutely clear that a conciliatory, to read the mediation approach, must be followed. And it also says variously throughout the Act that various people have voices and that moms and dads have to consult and take the views of their co-parent and the child into account in the decision-making. Plus, they have to attempt a parenting plan, which means with a social worker, mediator, a qualified person, before they ever approach a court.
Yeah, that's true. So that's the Children's Act. What other laws or Bill of Rights or acts are there that protect us?
Well, there are quite a few. I'm going to give almost all of them. You've got the Bill of Rights in the Constitution, so which is ultimately backed by the Constitutional Court. And what is in our Bill of Rights? Well, equality and protections from abuse, discrimination, unfair administrative processes. So let's take from the constitutional or the Bill of Rights promise of equality as 50-50. Okay, so there's a Domestic Violence Act, and that's backed up by the Domestic Violence Court. And that protects you and your child from physical violence, emotional violence, verbal violence, extortion, or economic abuse, threats, intimidation. So, for example, I can't say to you, don't divorce me, otherwise I will kill you. Or if you don't pay me so much, you'll never see your children again. That's intimidation, those are threats, and that's covered by the Domestic Violence Act. And if you experience that, you can go along to the Domestic Violence Court. And if the person then breaches the order, you can then take that, the warrant of arrest to a police station, which will then be heard in the criminal court. So very powerful mechanisms available to the abused victim, a parent or child in a divorce. What else? The Children's Act. The Children's Act has criminal sections. The Criminal Act is where we go to hear that the voice, that the child has a voice, that family has a voice, that both parents must co-parent and consult each other. And failing which, there's certain sections, for example, Section 35, that says if somebody secretly relocates with a child, that's a criminal offense. You're looking at a year. If a parent fails to pay maintenance, that is a criminal offense. fails to, if a parent or a caregiver abuses or neglects a child, that's a criminal offense in terms of Section 305(3). So, so how does child abuse and child neglect feature in divorces? Well, if somebody is alienating a child, saying dad is bad or mom is mad, don't go there. Aren't you scared to go to daddy this weekend? Don't you think mommy is going to do something wrong to you? Well, that's grooming, coaching, that's alienating a child, that's psychological abuse, that's covered by the Children's Act. A lot of people are saying that we need to have the Brazilian style legislation, which explicitly mentions parental alienation and says this got to be a crime too in our law. That would be nice, but what we've got is very powerful. So parental alienation, grooming, coaching, fighting from the children, that's terrorizing. Those are all psychological crimes, and the children and the co-parent is protected by the Children's Act. Now, the common law, we have a common law in South Africa, and our common law also has common law crimes: fraud, defamation, perjury. So let's talk about defamation. Very often somebody sees the benefit of making some sort of accusation to win the divorce. He hit me, or he's looking at my daughter funny, or she's not well, she's mental, she's a narc.
Yeah.
Well, if it's not true, it's defamatory, and the aggrieved person can go to a police station, also civil court, but why not try the police station and open up a common law crime of defamation or criminal injuria, and then launch a process that way to remedy procedural abuses, or to remedy those types of dirty tricks that we see so often in divorces. So we have the common law, we have the Domestic Violence Act, we have the Children's Act, we have the Bill of Rights and the Constitution. We also have the Act which creates the Office of the Family Advocate, the Mediation in Certain Divorce Matters Act. So South Africa has a wide range of laws and courts that are either intentionally or are available to moderate the divorce, pacify the divorce, restrain a high conflict personality, and ensure a just outcome, a peaceful, fair divorce.
So it seems that we are well protected in terms of the law. But then what is the problem? Why do we have so many problems? Why do we have so many high conflict divorces and divorces that drag out for years, and horror stories that we hear of alienation and all that sort of stuff? Why is it still a problem then?
Well, all too often, the wonderful promises of the law exist in paper only. So there's the substantive law, which is what is promised by the acts, but there's also procedural law that says what actions are available to translate the promise into reality. And sometimes people don't have actions, or or it's too difficult, or it's too hard, or the actions take too long. So theory is not always practiced in South Africa.
Okay. And who are the people beside the law that are supposed to protect us? You mentioned going to the police station.
Okay, so there are a number of, let's call them guardian angels. Okay, so let's imagine a scenario. Mom and dad have reached the end of their tether. There's been just too much domestic violence or fighting or unhappiness, and they agree to divorce. And then somebody, let's say that somebody goes to a lawyer, or somebody gets advice from a mom-in-law, or an angry friend says, "Hold on, get him or get her," So all of a sudden, a troubled marriage becomes a high conflict divorce. Now, the parents would hope, or you would hope, that in the best interest of the children, there would be a number of third parties with the mandate, the power, the responsibility, the authority, the incentive to climb on board and to pacify the situation. Well, there are a number of people in our law who could or should jump in to pacify the situation. Lawyers. The divorce lawyer is an officer of the court The Children's Act says that in all matters involving children, and a divorce with the children is it, they have the duty to put the interests of the best interests of the child before the interests of their client. The police should be available, the magistrates court, the domestic violence court, the criminal court. You can marry in the magistrate court, so the divorce court presiding officer, clerks of the court, social workers, psychologists, the family advocate, the family counselor. Above that, the regulators, the Health Professional Council of South Africa for psychologists, the Law Practices Council for attorneys and advocates, and the South African Council of Social Service Professionals for social workers. And they are bodies overseeing the behavior of magistrates and judges. So there's a whole bunch of people on the ground with the mandate to watch over the child, and therefore to restrain a sort of high conflict personality who might be abusing the child to win a divorce.
Yes.
A whole bunch of people on the ground who we should be able to turn to, plus a whole bunch of regulators behind those people to bring, enforce quality and ethical standards in those people. So a high conflict divorce can often involve, Sinta, not just me and you and the mediator. A high conflict divorce can actually involve a team of people that might be 10, 15, 20 people. And the truly high conflict divorces might actually touch sides with 10, 20, 30, 40 people in the course of the divorce.
Goodness, and that's why it's so expensive also. So talking about all those people that could get involved, can we get an explanation from you, or a description or a summary about your particular work about in the unfair tactics and strategies that are used, and that you've named the windmill? And please explain to us what that is and how that works, because I think it's very important that people be aware of these strategies that are used, because they're very common actually.
So sometimes I must tell you, I was such a naive divorcing father myself at the time. I had studied law way back when at Wits and UCT, and I never read articles. So I had this naive view of the theory of law, and the theory of law is absolutely beautiful. But I had zero understanding of street law, law as it actually is practiced.
Yes.
So when I had my experiences, I turned to all the people I could think of to pacify the situation. And it just didn't work out the way that I expected. And I also found that the machinery that was brought against me was absolutely slick and polished. It made me think, hold on, is there some type of strategy behind the sequence of events that I'm experiencing? But I mean, you can't create a theory out of a sample size of one. So when my divorce was over and I met Lorraine and we married, and we launched the Justice and Reconciliation Center, we thought that we would be doing mediation in terms of the Children's Act. We were looking forward to diverting high conflict personalities to mediation. And then, lo and behold, the clients that came our way were all battered victims of high conflict divorces that fell into patterns. So some divorces seem to be characterized by a domestic violence accusation. Another one might be a molestation accusation, and a range of defamatory accusations, and they all had the effect of starting the divorce in a court other than the divorce court.
Interesting.
Okay. So what they were doing was that they were shaping the outcome of the divorce according to the nature of the starting court. And this was clever, and I realized it was a strategy. Of course, it's a strategy that's made possible by the architecture of South Africans legal, by our legal system, and the range of courts and the and the conflict of laws. So let us have a look at what is the philosophy of the family of the different courts. Because what is the advantage in the divorce of starting with a domestic violence action or a criminal action? Well, the divorce, since the Children's Act came out 2007 and 2010, it created a tendency or a bias towards 50-50 mediation. Now, there are some personalities who do not want 50-50. And they aren't even satisfied with the 80-20 where dad gets every second weekend. They want 100 naught.
Yes.
So healthy people, balanced people want 50-50. Slightly unbalanced means 80-20. And extremely unbalanced people want 100 naught where somebody gets eliminated. Sometimes the elimination is through assassination. And there are cases in South Africa where somebody hired hitmen to take out the husband or the wife who were in the way. So let's say we're talking about someone who, for whatever reason, wants to totally eliminate the co-parent. Well, then the Children's Act is an obstacle. Then mediation is an obstacle because the Children's Act and mediation will tend in the direction of 50-50. So they have to look for ways to cancel the impact of the Children's Act. And you can do that in South Africa if you can start off with a domestic violence action or a criminal court action. And why is that? The model of family is very different. The model of family in the Children's Act is mom and dad together co-parenting, safest situation for the kids. Children's Act wants co-parenting because it sees cooperation between two healthy parents as producing the safest environment for the children. And that's dead right. That's exactly how it is. Okay. Now, the model of the family in the Domestic Violence Act is very different to that. In the model of the family in the Domestic Violence Act, it's women and children versus the man. So it's quite,
why is that the case?
The Domestic Violence Act is quite gender prejudiced. The prelude to the act makes it quite clear that the origins of the act is to protect women and children. Well, by implication, from who? From the man. By definition, we are looking at intimate relationships. You're looking at parents. So the model of the family in the Domestic Violence Act is mom has to be protected from the abuser, who is the father, and the child has to be withheld from the father, who's the abuser. So that is the model. That is the mental model that's behind the Domestic Violence Act. It's also then, so it also shapes the procedures of the domestic violence court. And as a result, you can get an action very, very easily that eliminates dad's contact. So it's happening all the time around the country, is that people who have a divorce agenda, who want to overturn the 50-50 promise of the Children's Act, they begin in the domestic violence court because their starting point is, I want a protection order that eliminates most often dad's contact. Because if dad is eliminated from contact right from the start by a protection order, which can be an interim order that's simply kicked down the road forever until the divorce finalizes. If we can cancel a parent's contact up front, we can start breaking the bond.
Yes.
And then down the line, we can bring in a hired gun. The hired gun can truthfully or untruthfully say, oh, the child's bond with the target parent has been broken. Therefore, we recommend only supervised contact, not the contact the relationship is stressed, therefore give more contact to restore. the contact has been stressed, has been reduced. So as a result, make even less in the future and make sure it's supervised, because that makes money for the social worker making the recommendation or the social worker's colleague who gets nominated. So, so the whole sequence is start the Domestic Violence Act, position, typically the dad, position dad as the threat, use the interim protection order, which was acquired in his absence, use the protection order to cancel his contact, limit his contact, and present him as the baddie.
Yes.
That will then taint, discredit the target. So when social workers, psychologists are brought into the picture, they can be shown the application. They launch off with therefore dad's bad or mommy's mad, as the case may be. And then they can produce reports that by defining the parent as a threat, justify down the line a one-sided settlement or trick the family advocate into producing a report that recommends a very lopsided situation. And of course, say the recommendation is dad gets 4 hours a month supervised. Even that will turn out to be more than the father gets, because down the line, the alienator's primary residence will be used to groom and coach the child until the last vestiges of love have disappeared, or trust and respect have disappeared. And then the voila, the golden moment for the alienator comes down the line when the child uses his or her voice and says, I don't want to see daddy anymore. I don't like mommy anymore. Okay, so that is, so the deliberate use of the domestic violence application is in order to hijack the domestic violence court to shape the divorce settlement.
It seems so easy to just eliminate the other party with a strategy like this. But does it start on the premise of a protection order was already granted, so there must be truth in this? And the social workers or the people just run with that without actually properly examining the situation or investigating? So,
I mean, South Africa has amongst the world's best, smartest people. I've just got off a Zoom now and I was speaking to an advocate attorney, and I was blown away by their intelligence, their wisdom, their knowledge of the law, their concern for the children. You know, it's the more you know lawyers and social workers and psychologists, the more you are blown away by the quality. Trouble is, everybody's overloaded.
Okay.
And we are all human. So what happens is, South Africa's caseloads, we have social workers who have 80 cases. Well, the global norm is 20. So we have lawyers who have piles of cases on there. People simply cannot give cases the attention they need. So if somebody comes to you and spins a plausible story, my husband did this, my wife did that, and it seems to be backed by, it seems to be blessed by some type of court order or some type of report, we do tend to, no matter how clever the people are, no matter how smart and all those things the people are, they tend to, in the moment, accept what's in front of them and not look further. And it's almost game over for the victim. Because once the first reports and the first court orders taint that person, discredit that person, present that person as a threat to the child, then this happens. Nobody afterwards, no matter how good they are, because they love children, because they are law-abiding, nobody afterwards is going to do anything that puts the child at risk by putting the threat closer. So the target, no matter what the truth is, once the target is tainted, then good people will bend over backwards to remove the child from that target's life. And if you're relying upon those professionals to protect your 50-50 or to cancel false orders or to accept your criminal case, those people have been so prejudiced against you by those early warnings or by those early reports or court orders that there's almost no hope. And that brings us to hired guns.
Yeah, so the case is so tightly built right from the start that there's actually, short of being a lawyer yourself, what are you going to do as a lay person?
Well, I agree with you about the tightly packed, and it was the tightly packed. It was the slickness. It was the speed by which one-sided and even false and defamatory cases are assembled that opened my eyes to a factory, the windmill factory. The fact that lawyers exist who have over the years, I mean, a lawyer who is smart can be smart in the service of good and smart in the service of evil. Is that South Africa's smart lawyers, some of them have developed over time a very slick mechanism to win the divorce on behalf of their client by gaming the system and by producing false reports. And attached to that then is a syndicate. So a lawyer who runs a windmill then puts a call out to a hired gun, for example, Ruth Garb, puts a call out, and then Ruth Garb arrives, does a quick interview, writes the report requested of her, hides the report from the target, doesn't consult with the target to check if anything that she has been told and has written down is true, and now then provides an ambush report that then is used against the target in, for example, the domestic violence application or in the hearing to finalize the domestic court. So our clever lawyers have over the years, some of them developed clever strategies. I call them windmills. And those windmills rely upon an army, a syndicate of social workers or psychologists, and the hired gun is who will write a report that accuses a third party who is not in the room, will simply copy and paste the accusations presented as if they were true without checking them. And especially, I mean, South Africa supposedly has a rule of hear the other side.
Yes.
So a hired gun who writes a report and criticizes and condemns somebody, and especially makes recommendations limiting their contact rights without ever lifting the phone up to say, look, is this, Mr. Goetsch, is this true?
Yes.
Or Mrs. X to B, is this true? And then secretly hides that report so that the lawyer can then submit that court and ambush the target in court. So that slickness, that speed, that machinery, that knowing, that gaming the system, it relies on the lawyer who knows the system, and it relies on a psychologist or social worker who is prepared to sell their credentials for money, who's prepared to put their name to a false report. And often that's all that's needed. Because if you can get one, let's call it a false report, and you can ambush a person in court, you've now got a false report, and some type of settlement or court order.
And I believe this is done with great speed also, hey? It's worked through the system very quickly.
Well, you can go with your false claims. Let me think about my situation. You can go in with your false claims on Monday morning.
To the police.
She can get the interim protection order that afternoon that expels you from your house and contact with the children. Now that she's got control of the children, she can take the child the next day or the children the next day to, for example, Ruth Garb, who will then produce a report 4 or 5 days later in time for the hearing to finalize. So you can have, in the space of 1 or 2 weeks, both an interim protection order and a report, and then leverage the two of them to get a protection order. You can get 2 official documents and a forensic report all in 1 or 2 weeks at the start of a divorce.
Yeah, that's really frightening, really frightening. Yeah.
To me, the frightening thing is not, the frightening thing is the people who are asleep. I have great sympathy, it might sound odd. I have great sympathy for people who have mental issues. My
Mm.
mother died of cancer, for example, and you can't blame someone for being physically sick.
Mm.
It's just this is how it is. And
This
when
is not,
we marry for in sickness and in health.
that's true.
And we marry someone who might get a dread disease and die of cancer. We
Mm.
might marry someone who turns out to be bipolar.
Mm.
Or we marry that person. We love that person. Just because they develop something doesn't mean that we turn against them, that we reject them. So I have great sympathy for people who, for no fault of their own, have a physical disease or a mental disease.
Mm.
I also have I have no sympathy. I have sympathy for lawyers.
Mm.
They don't know when a client comes into their chamber and says, "My husband raped me," or "My wife's a knock." They don't know if it's true or not. They don't have forensic investigator to check out. So it's easy for good people to be emotionally captured by a sob story.
Mm.
Okay.
I like the
So
term that you use, emotionally captured, because that's what happens, and that's what makes it tragic, actually.
a lot of people complain that that magistrate did this, and that lawyer did that. They must have been bribed, or that social worker was bribed. No, very often it's good people who land up doing bad things because they fell for a sob story. Their heart, their good heart, their compassion has been manipulated by a trickster, and they didn't they didn't check what they saw.
Yes, and those are the things that specific personality disorders are particularly good at, is manipulating and telling stories and winning people over, which makes it so difficult.
So, I have a special interest in the borderline personality disorder, and it's a horrible disorder to have, because it's the person is so stressed. With narcissism, the person has this inflated sense of self. But with the borderline, you think that you're bad, or you know that you're bad, and you're always scared of people finding out.
Yes.
It is it's a terrible strain to have that type of psychology happening inside our head. I have great sympathy for that type of person with that type of situation. And of course, it's easy for the children to be emotionally captured by that, because they see mommy or daddy crying. Because a borderline is very up and down, is very prone to depression and to tears. So the children see the tears and they think that person must be the goodie and the other person must be the baddie because they see a person crying. So I have great sympathy for both for the person with the disease and for the laymen who are captured by the show.
Yes.
What I struggle to have sympathy for is the professionals whose job it is to spot and stop child abuse. So Office of the Family Advocate, for example, the courts High Court, Children's Court rely on reports produced by the Office of the Family Advocate. Well, that's the family advocate, that's a lawyer, and the family counselor, that's a social worker. And they work as a tag team.
Yes.
And they interview the two parents and they produce a report. And all too often, to back up your point about how manipulative a disorder can be, between the family advocate who doesn't understand, who's not trained in psychology, and the social worker who's not trained in psychology, they don't spot the manipulator. They don't spot when somebody wants sole custody or primary residence or to eliminate the rival. They don't see, hold on, why is somebody so extreme? Is it possible that this person who's posing as I'm anxious on behalf of my children, and that's why I want my co-parent to be eliminated forever? They don't spot, hold on, there's something wrong with this picture. They don't start, right up front, and we spoke about 50-50. And as the default setting. Our Office of the Family Advocate simply do not start off with 50-50 default setting and then put the burden on the parent to justify deviation from 50-50. They seem to start, in my experience, they seem to start off with an 80-20 principle, where mom gets 80, dad gets 20, and dad has to defend even his 20. And if mom is going to eliminate dad totally, 100-0, they're willing to go along with that without actually looking too closely as to what's going on.
Yes.
So my concern is, to be blunt, my concern is that the expensive quality control system, expensive for the taxpayers to pay, costing a whole bunch of resources from the Department of Justice. My concern is that in that fragment of divorces known as high conflict of divorces, where by definition the children are at most risk. The children are at most exposed to domestic violence in the marriage, domestic violence in the divorce, most at risk of being raised by the psycho, most exposed to alienation, coaching, grooming, etc., etc. In other words, the case that most needs special attention. The Office of the Family Advocate is structurally unable, because there's no psychologist in the mix. They are unable to pass to implement a diagnostic test. And then I have the family advocate, I believe, the Office of the Family Advocate, the lawyer, I believe, is applying the wrong law. They seem to be applying the Divorce Act and not applying the Children's Act. And there is the most superficial lip service that's paid to the Children's Act, because you will see the obligatory reference into the children and the total abandonment of Section 2.1, which is the promotion of the family, the preservation of the family. Okay, so to be absolutely frank, to be absolutely blunt, to be absolutely unhappy about the status quo, I am deeply concerned that the Office of the Family Advocate seems to be running to regulations that were designed before the Children's Act, and rather than being protectors of 50-50 and guarantees of the safety of children, they are in fact implementing a lopsided, old-fashioned status quo, which is an absolute blessing for alienators who want to eliminate a rival. So we have an expensive quality control system. I'm questioning whether that quality control mechanism is functioning at all. Obviously, you have individuals who are brilliant. You have individuals that are just wise and prudent, and they care, and they put months and months and months of work into cases, and I've seen their reports. You have brilliant people doing wonderful things, but the institution is broken. The institution is running on the wrong lines, and the essential and certain people who are needed for high conflict cases, the psychologists, are missing from the picture. And the family advocate, the lawyer involved, I don't want to say they sleep and they're living in a different universe, but they are not applying the Children's Act as it is written. Especially, they're not applying the full section. They're not applying the full Section 7 of the Children's Act, which is a test for what must be in a report, and they're simply leaving out so much of what is compulsory in the report that they're allowing bad things to happen.
Yes, and I've seen these cases, similar cases, play out so many times. It happens over and over again. And to me, I just come back to one thing, and there's a good reason why it's called family law. Handling family matters. And I agree with you that we're doing everything based on the wrong laws, and we're not actually practicing family law when it comes to divorces. And I think that's the root of the problem.
Over time?
Yeah.
Okay, and I've got a 12:30. I'm now very late for.
All right, well, thank you for that so much. We'll catch up again. Thanks, Errol.
Cheers.